Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Today I want to briefly discuss what happens when your bank account is frozen from a judgment and what you can do about it. Now, this video should not be construed as legal advice and is only intended for Indiana residents utilizing Indiana law. Now, imagine that you go to make a purchase with your debit card or pay a bill online and the transaction is declined. You know it should have gone through because there's enough money in the account. So you check with the bank and there is money in the account, but it's been frozen by a court order. If this has happened to you, then you already know that this happens without any warning in advance, and it can be a terrible situation to be in. And to further add insult to injury, you find out after the account has been frozen that a court hearing on the matter has been set about the status of the account, but it's probably going to be about 6 weeks away or so. Over the years, I've heard many nightmare stories from clients who have had this happen. People who have gotten stuck traveling out of state with no way to get home. People who have had to beg and borrow from friends and relatives just to pay rent or utilities. I had a lady who called me one year, 3 days before Christmas. It was a Friday, and they froze her bank account that day with her paycheck that just went on deposit, and she couldn't buy any Christmas presents or anything. She was crying hysterically. And of course, it being the Friday before Christmas, there was absolutely nothing we could do about it. So terrible, terrible things can happen when an account is frozen. But how does this happen? So in Indiana, a bank freeze will typically begin with a defendant losing a lawsuit and becoming what's called a judgment debtor. And that is in relation to the plaintiff, who becomes the judgment creditor. The judgment creditor goes back into court and asks for a motion for what's called proceeding supplemental to be filed to find out how they're going to get paid on their money judgment against the defendant. And one of the more common things they will do is ask the court to send an order to the judgment debtor's bank. Once the bank receives this notice, they are required by law to put an automatic administrative restriction on the account. The bank has a very small amount of due diligence that they have to do to make sure that the account doesn't contain money they know to be exempt from lawsuits, like money from Social Security, for example. But beyond that, the bank just freezes the funds on deposit and leaves the judgment debtor to figure out things with the court. And the worst thing is that without a court order releasing the funds, a bank is required under Indiana law to restrict the account for up to 90 days. Now, here's the part that many people don't know about. You don't have to wait for the hearing date that the court automatically sets. You or your lawyer can file a motion for an expedited hearing, and Indiana law requires that upon doing that, they have to get you in on a court hearing within the next 5 business days. That way you don't have to wait a month or more to find out what's going to happen with your money. Now, here's the part that you're probably not going to like. And I say with all my clients in this situation, I hate to be the bearer of bad news, but if it's a valid judgment against you and the funds on deposit aren't specifically exempt by law, there is very little you can do to get that money back. And as I said earlier, Social Security is exempt. Money on deposit that is traceable to, say, a joint depositor who has nothing to do with the lawsuit, they can't touch that money. But if your money on deposit is just general funds like money from your paycheck, the only amount you can protect under current Indiana law is $450. Anything above that, they can take to help satisfy the outstanding judgment debt. So unfortunately, they don't have any regard for what other bills you have to pay or children you have at home to feed. I've been to many court hearings where the courtroom was full of people whose accounts had either been frozen or wages garnished, and people will be crying and pleading with the judge to help them. I mean, it's sad. It's a sad situation to see. And much like wage garnishments, which my other video discusses, if you owe money on a judgment, the law dictates that they can take your money to pay it off, and you can only protect $450 in the bank. Now, bankruptcy is a comprehensive solution to addressing overwhelming debt and stopping things like wage garnishments and bank account freezes. So if you've been sued and lost a judgment, you may consider bankruptcy as a solution to protect your future wages from garnishment and your bank accounts from being frozen in the future. If the account has already been frozen, it's too late for that money that was in there, except for the $450 that you can get freed up by court order, or other funds that, again, may be exempt by law. So that's it for today. I hope this video was informative. For more information, contact my office. Click like, click subscribe to follow me for future videos. And as always, thank you for watching.